Thank you very much. And I congratulate Professor Mohan Gopal and his fellow members in the team. Article 16 focus team, as it is called. I am very happy about the designation of the team. Honorable Mr. Justice Charmeshwar, Professor Gopal, my brother Justice Ishwar, and fellow panelists, ladies and gentlemen. At the outset, I would request you to kindly have a look at the PPT presentation. I'll put it on this thing. The first and foremost thing is, before we consider constitutional validity or the basic structure of the amendment, it is necessary to look into the origin of the concept of social justice. Now, this we will get, if I may say so, in respect, the first order of reservation was thought of immediately after the first census in the year 1872. 1872 census. I think there is some echo. Echo is coming.
Yeah, the same problem.
We can hear you clearly, sir. I can hear you clearly. Yes,
Okay.
yes.
Thank you. So, 1872, for the first time, census was conducted, and what is very important is the population of each caste was made known, and particularly the population of Brahmins was made known, because till then nobody knew what is the population of backward classes. Everyone thought it's a very big community. It was discovered that it is a minuscule, tiny community, but which has predominated all the employment sector and all other spheres, particularly the professions. So that is when in the then princely state of Mysore, in 1874, the first reservation was thought of and provided. In the police department, in the posts of inspectors, sub-inspectors, head constables, and the other cadres, a reservation was provided, providing second and 10th appointments to be made from the Brahmin community, and the rest of the posts to be filled up by non-Brahmins. Now this was introduced in 1874. It continued and was reviewed in 1895 after the second census, third census, and later it was discovered that this has not helped to improve the representation, because in the year 1916, as we can see from the table, the 1916 recruitment showed 72% of the posts went to Brahmins. 1917 recruitment showed 74.37% went to Brahmins, and 1918 showed 74% went to Brahmins. So therefore, for the first time, the then Maharaja of Mysore, Nalvadi Krishnaraj Wadiyar, he thought of appointing a committee to examine the various measures to be introduced. Chief Justice Leslie Miller, an English judge, who presided over this committee, and he drew up a huge plan as to how to improve the representation of non-Brahmins. What I request you to kindly take note is, the only reason why these measures were introduced was to bring down the preponderance of Brahmins in the state administration. That was the reason. Now, after this was done, Chhatrapati Sahu Maharaj in Kolhapur introduced reservation in the year 1902. Then Travancore Cochin state introduced communal rotation. Then in the central services also, in the central services, one second. In the central services also, reservations came to be introduced. And what is very important is the object of these reservations was to bring down the representation of Brahmins, which community, though constituted only about 4% of the population, had monopolized the entire state services. And as the figures are available now, the result of these reservations were salutary, and as the figures are available now, we can see that by 1946, the percentage of population which was around 90% and odd, the Brahmins representation in state services, it came down to 1946, it came down to 49.36% Brahmins, and in non-guested posts 38.43. By 1952, it came down to the Brahmins reservation came down to 39.4 in guested posts and 38.3 in the non-guested posts. So this was the situation when India became independent and we had a new constitution. So the first development was the appointment of the Kaka Kalalkar Commission, by which time 12-point reservation had been provided in favor of the scheduled castes, and reservation was also provided in favor of the scheduled tribes to an extent of 5%, and the National Backward Classes Commission, under the chairmanship of Acharya Kaka Kalalkar, recommended reservations to an extent of 25% in class 1, 33 and 1/3% in class 2, and 40% in class 3 and 4. And in so far as the educational institutions is concerned, it recommended 70% reservation. But as already noticed, this report was shelved, and no steps were taken to implement the report. Thereafterwards, the second commission came into being, and it recommended 27% reservation. The Mandal Commission report, as it is popularly known, it recommended 27% reservation. And by OM dated 13/8/1990, this was implemented by the VP Singh government, and the government, mainly for implementing this, it lost its office after implementing 13/8 on 13/8 27% reservation. It lost its power, and the new government which came into power, it amended it, and by 25/9/1991 OM, 10% reservation was given in favor of other economically backward sections, which are not covered under the existing schemes of reservation. This was challenged, and Indrasani on 16/1/92, in the case of Indrasani versus Union of India, Honorable Supreme Court upheld the 27% reservation, but struck down the reservation provided in favor of economically backward sections. I have culled out some of the findings. Any reservation resulting in curtailing the right of equal opportunity is to withstand the test of equal protection or denying discrimination. The latter has been permitted for a class which has suffered injury on the past and is suffering even now. Economic backwardness does not qualify for such protective measures. Economic backwardness would not be eligible for the benefit as it would be incapable of satisfying the other mandatory requirement of being inadequately represented. Kindly mark this, this is very important. Inadequately represented and consequently the reservation in favor of economic weaker section was struck down. Afterwards, what is very important to take note of is we have the 103rd amendment by which 10% reservation is now introduced by way of an amendment to the Constitution. And at the start of this PPT, you will have noticed the statement of objects and reasons. I'm extremely happy that Professor Mohan Gopal has hit the nail on the head when he said, whole thing lacked transparency. And the way it was pushed through, hurried through, without any debate, itself is a clear indication. Please see the objects and reasons which I put it at the beginning of this PPT. It reads like this, I quote, at present, the economically weaker sections of citizens have largely remained excluded from attending the higher educational institutions and public employment on account of their financial incapacity to compete with the persons who are economically more privileged. Kindly mark it. Now, this does not say who are these economically weaker sections in the statement of objects and reasons. But it is a fallacy to claim that they remained excluded from attending the higher educational institutions or the public employment. There is absolutely no material whatsoever, no empirical data to support this conclusion, which preceded the introduction of the bill to amend the Constitution. And the next sentence, the benefits of existing reservations under clauses 4 and 5 of Article 15 and clause 4 of Article 16 are generally unavailable to them unless they meet specific criteria of social and educational backwardness. Yes, when they are designed to provide ameliorative measures only to socially and educationally backward classes, the forward classes cannot aspire to get the protection of reservation. So it is with this object the amendment came to be introduced. Now see the amendment that has been introduced, and very importantly, Honorable Justice Chalmeshwar has rightly opined that this definition of economically weaker sections is a nebulous one. It is transitory, and this is how it reads as per the explanation to Article 15, Clause 6. I quote, for the purposes of this article and Article 16, economically weaker sections shall be such as may be notified. So they are not defined. It is left to the state. As may be notified by the state from time to time on the basis of family income and other indicators of social disadvantage. So it is not defined as to who are these economically weaker sections are going to be. But most important, in my very respectful opinion, is that this 10% reservation is not for the so-called economically weaker sections, but for those who are left out of Article 15.4 and 16.4, as the provision itself says. For example, 15.6 says, any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and 5. So 15.4 and 15.5 classes are eliminated. Likewise, Article 16 also, Article 16.6 Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in clause 4, that is article 16.4, in addition to the existing reservation and subject to a maximum of 10% of the posts. So it is not economically weaker sections is not the factor, but the caste to bring down whose preponderance reservation was contemplated and introduced are the castes which are benefited by these provisions, both 15.6 and 16.6. In other words, the Brahmins and the Baniyas who were left out of the reservation scheme under 15.4 as socially and educationally backward classes, or as backward classes under 16.4, are the beneficiaries of this provision. 5% population mainly. It is purely on the basis of caste, but euphemistically described as economically weaker section. It's a fraud. The act of providing reservation is to these two castes, and to camouflage it, it has been described as economically weaker sections. So the question before us is whether such an amendment is hitting the basic structure of the Constitution. Honorable Justice Chalmeshwar has already pointed out how it violates the basic structure. I have elaborated on that. Kindly consider, Honorable Justice Chalmeshwar pointed out about the efficiency of administration. While for 16.4, efficiency of administration is a hurdle, but for 16.6, the so-called economically weaker sections, it need not be subjected to any efficiency test at all, because the beneficiaries are considered to be embodiment of efficiency of administration. Though no commission has found that providing reservation in favor of scheduled castes and scheduled tribes or the socially and educationally backward classes has brought down the efficiency. Repeatedly it has been held that it violates the efficiency requirement under Article 335. I therefore would like to point out that 15.4 and 16.4 are measures in a welfare state intended to bridge a gap between the haves and the have-nots, and particularly the provision made and the debates on the floor of the Constituent Assembly, where it was specifically understood, as is clear from Dr. Ambedkar's statement, that there must be at the same time a provision made for the entry of certain communities which have so far been outside the administration. There shall be reservation in favor of certain communities which have not so far had a proper look in, so to say, into the administration. And the administration, which has now, for historical reasons, has been controlled by one community or controlled by one community or few communities, that situation should disappear, and the others also must have an opportunity of getting into public services. So it is this that is being reversed. So the question is, the constitutional goal of a welfare state to bridge the gap between the haves and the have-nots, to provide a level playing field for those who are kept out of the educational institutions and the services under the state, is being reversed. Now that is the question before the August Assembly, to decide whether this would be infringing the basic structure of the Constitution. In Coelho, the Honorable Supreme Court, a bench of 7 judges has already declared that destroying an identity of the constitution, constitutional identity, would be violating the basic structure. And therefore, my very respectful submission is the basic structure is violated when you destroy the identity of the constitution. As Honorable Justice Chalmeshwar has already opined, Articles 14, 15, 16, read with Article 335, should be considered as one concept of equality, and that is being annulled or reversed, and therefore it definitely violates the basic structure. And if I may say so with respect, Coelho has directly mentioned these provisions, Articles 14, 15, and 16, and also the constitutional the identity. Therefore, this is definitely this. Most important factor is that it is not economically weaker section that is the crux of the matter. The crux of the matter is other than those which are already covered under Article 15.4 or 16.4. So that is the main issue. That is they are the main beneficiaries. Those who are not under 15.4 and 16.4. In other words, this is a revengeful act for those for whom reservation is provided under Articles 15.6 and 16.6. While the definition of socially and educationally backward classes is very well defined, this thing. Honorable Justice Chalmeshwar has rightly said, this is a nebulous concept, economically weaker section concept. If a man squanders all the property he has today, tomorrow he will get into the list of beneficiaries under Articles 15.6 and 16.6. So therefore, this is definitely a slippery terminology. But more importantly, the entire object is to provide reservation for those who are outside the 15.4 and 16.4 lists. Nearly 80% of the population is covered by the reservations that are existing under 15.4 and 16.4. So the rest of the population, just about 20% of the population, will be getting 10% quota. So this has already been challenged, and 4 questions which are referred to a Banias is only on the basis of their caste and not any other factor, because there are economically weaker sections among the backward classes, socially and educationally backward sections, as well as scheduled castes and scheduled tribes. So this is a naked act of caste discrimination in favor of the mighty powerful communities, namely the Brahmins and Banias, thus violating both Articles 15.1 and 16.2 of the Constitution. Thirdly, more importantly, the test of adequate representation. It is not applied to these categories, these 15, that is 16.6. While for 16.4, you have to pass the test of adequate representation. You may be socially backward, but you have enough representation in the state services, you will not be eligible for reservation. But that test has no application when reservation is provided under Article 16.6 in services under the state. So for these reasons, I would very respectfully submit that the amendments violate the basic structure of the Constitution. And one of the tests I would like this assembly to deliberate is, in less than 24 hours, the entire constitutional goal and the constitutional value of a welfare state, of a social justice state, of a socialist state has been reversed. The bill was introduced on 7th January, and same day it was passed by the Lok Sabha. It was introduced in the Rajya Sabha on 8th January 2019, and on the same day it was passed by Rajya Sabha. So therefore, such a hasty decision, such a passage of the bill without due deliberation, without wider consultation in the nation, and member of the Parliament, Madam Kanimoli, demanded the bill to be referred to a select committee for deliberation. It was not agreed upon, but hastily it was passed. And what is tragic is, my dear friends, I would request you to, all those who are elected in the name of Ambedkar in the reserved constituencies have voted in favor of this bill to defeat the very object of the reservation that was provided by Baba Saheb Ambedkar. So that is a clear indication how all the political parties are controlled by these advanced communities. That's a very, very clear indication. In fact, Justice Professor Mohan Gopal had already highlighted the lack of transparency and lack of debate on this. I concur with him, and the matter is now before a constitution bench. I hope there will be a wider debate throughout the nation on the conspiracy behind this amendment. Most important, the conspiracy behind this amendment, and most naked act of caste discrimination in favor of castes to whom no reservation was provided, either under Articles 15.4 or 16.4, they being the beneficiaries of this. So, with these submissions, I would like to point out the economically weaker sections reservation provided up to an extent of 10% is a constitutionally impermissible reservation, and it is opposed to basic structure, and therefore it deserves to be annulled. Most important factor is, at least now there should be a wider debate, and I am sure this will be a very challenging question before the Honorable Supreme Court also. The situation in the Supreme Court, if we take the social background, Honorable Justice Chalmeshwar will know the social background of the sitting judges. I think hardly 2 or 3 people will come under the reserved category. There is no SC judge, of course. I think 1 or 2 are OBC. There is 1 SC judge. The rest of the judges are all coming from the so-called economically weaker sections. So it will be a challenging task for the Supreme Court as to how it is going to deal with this question. And the delay is already an alarming delay. It ought to have been decided long ago, but there is no interim order, and the issue is not yet decided. So that gives room for anxiety on those who are vitally affected by this. 80% of the population is affected, and to these 10% posts, all others, that is 80% of the population, are disqualified because they are beneficiaries under the 15.4 or 16.4 list. So these are the questions before this August Assembly. In my humble opinion, I respectfully concur with the theme of this discussion, that it is violating the basic structure. Thank you very much for this opportunity.